You're sitting on the side of the road when the officer asks you to step out of the car. He has a small device in his hand. He wants you to breathe into it. Most drivers think they have a choice here. Some think refusing protects them. Almost none of them know what actually happens next. Because in nearly every state, the moment you got your license, you already agreed to this test. You just didn't know it. It's called implied consent. Here's what that means. When you sign for a driver's license, you're entering into a legal agreement with your state. Part of that agreement says if a police officer has reasonable suspicion you're driving under the influence, you agree in advance to submit to a breath, blood, or urine test. You agreed to this before you ever got pulled over. You agreed to it the day you got your license. So what happens if you say no anyway? Let's reconstruct the moment. The lights are flashing in your mirror. Your hands are sweating on the wheel. The officer walks up, asks a few questions, and notices the smell of alcohol. He asks you to take a breath test. You refuse. You might think this protects you from a DUI charge. It doesn't work that way. Refusing the test triggers its own separate punishment, completely apart from any DUI charge. This is the part almost nobody understands. In most states, refusing a breathalyzer leads to an automatic license suspension, even if you're never convicted of driving under the influence. Some states suspend your license for 6 months on a first refusal. Others go even further. Why does this hold up legally? Doesn't the Fifth Amendment protect you from self-incrimination? This is where the Supreme Court stepped in. In the case Birchfield versus North Dakota, decided in 2016, the court drew a sharp line. Breath tests, the court said, are minimally invasive and can be required without a warrant. Blood tests are different. Blood tests are more invasive, so police generally need a warrant or your actual consent to draw your blood. But breath tests sit in a category of their own. Refuse one, and most states can suspend your license through pure administrative action, no courtroom required. So the breath test and the DUI charge are two completely separate legal tracks. One is criminal, one is administrative. You can beat the DUI charge in court and still lose your license for refusing the test that might have helped you beat it. Here's the twist almost nobody sees coming. In many states, refusing the test can actually be used as evidence against you in the DUI case itself. Prosecutors are allowed to tell a jury that you refused and let the jury draw its own conclusion about why. Jurors often conclude that refusal means guilt. So the very thing you did to avoid incriminating yourself in many cases becomes the incrimination. Now picture the other side of the scene. You take the test. The number comes back low, close to or under the legal limit of 0.08 in nearly every state. Suddenly, your case is far weaker for the prosecution. The evidence sometimes works in your favor. Refusing removes that possibility entirely, replacing it with an automatic license suspension and a refusal flag that follows you into court anyway. This is the part that connects back to something you probably do every single time you get in a car. You buckle your seatbelt without thinking about it. You stop at a red light without considering the legal architecture underneath that habit. Implied consent works the same way. It's baked into the privilege of driving itself. You agreed to a set of rules the moment you accepted that license, long before any specific night, any specific stop, any specific decision behind the wheel. States do vary here. Some states treat a second or third refusal far more harshly than a first. Some require an officer to read you a specific warning about the consequences of refusal before the suspension takes effect. The National Highway Traffic Safety Administration tracks these penalties across all 50 states, and it consistently finds wide variation, both in suspension length and in whether refusal itself can be charged as a separate additional offense. So is there ever a moment where refusing makes sense? Some attorneys argue that in specific situations, especially when the driver has a medical condition that could distort a breath reading, refusal followed by an immediate request for a blood test can sometimes work in a driver's favor. That's a decision that depends heavily on the specific state, the specific facts, and the specific officer's conduct that night. This video is general legal information, not legal advice for your situation, and if you're ever facing this decision in real life, the right move is to consult a licensed attorney in your state because the laws and the penalties are not identical everywhere. What this really comes down to is a simple piece of architecture most drivers never notice until the moment it matters. The choice to refuse was never really a choice without consequences. It was always a second test, layered quietly underneath the first one, waiting in the legal code of your state since the day you signed for your license. So you're sitting on the side of the road again. The officer is holding out that small device. But now you know what you're actually choosing between, long before the lights ever start flashing behind you.